Hello, good morning, friends. How are you all? Hope you are all busy studying different subjects, searching through the mobile, through the net, through the YouTube. Okay, keep it up. All the best. So we shall come to our topic. We are studying about judiciary, our court system in our country, and we said that we have court in the shape of a pyramid. On top most we have the Supreme Court, below that we have high courts, below that we have district courts and trial courts and so on. And we said if we are not happy with the judgment of one court, we can approach the higher court. That is one of the privileges that are given to the citizens of our country. Now, we shall say, do we have access to the court? Can every person go to the court? Or only rich people or powerful people can approach the court? Can an ordinary citizen go to the court and express his grievances, express his complaints? That is what we are going to see today. So you can take your textbooks, page number 61. Does everyone have access to the courts? Okay. So in principle, the citizens of India can access the courts in this country. So in principle, every person in this country is given opportunity to go to the court, to have access to the court and so on. And this implies that every citizen has a right to justice through the courts. So court is meant for everyone, not just meant for a group of people alone, but it is meant for every person, rich or poor, high caste or low caste. It is meant for everyone. And as you read earlier, the courts play a very significant role in protecting our fundamental rights. So the primary duty of the court is to make sure that citizens' rights are protected, especially the fundamental rights. So if our fundamental rights are violated, then we can easily go to the court and we can demand the right to be restored. That is the duty of the court, to make sure that every person's rights are kept up and they are given freedom to enjoy, benefit that rights. And if any citizen believes that their rights are being violated, then they can approach the court for justice to be done. So in case your rights are violated, right to be educated, right to be live, right to life, right to property, right to expression of freedom, all these are violated, and each one of us, one who is affected, can easily go to the court, and court will make sure that justice is being done. While the courts are available for all, in reality, access to courts has always been difficult for a vast majority of the poor in India. And legal procedures involve a lot of money and paperwork, as well as take up a lot of time. So we said the court is accessible to everyone. Everyone has law, but it involves a lot of process. It involves a lot of money. We have to hire the lawyer, we have to pay fees for them. So for a poor person to go to the court, it is not that easy as we think, because it involves a lot of money, it involves a lot of writing, paperwork, everything. So a poor person or who is illiterate, it is very difficult for him to go to the court, because he will have to spend a lot of money, he will have to completely depend on others and so on. So that way it becomes little difficult for the poor people and the uneducated people. And for a poor person who cannot read and whose family depends on a daily wage, the idea of going to court to get justice is often seems remote. So a person who is poor and a person who is illiterate, for him to go to the court and get justice is very risky, or it is very troublesome, we can say. And especially if he is only wage earner, if he is only breadwinner of that family, then it becomes very difficult for him, because if he goes to the court, many days of labor he will miss it, and that day he will not get the wage, and his people or his family will suffer. So that kind of problems are there. So he'll better think, better not to go to the court. Let me continue my work. Let me continue to look after my family. So such kind of thinking will come, because it becomes very troublesome for him, difficult for him to get justice from the court. And in response to this, so because of these difficulties experienced by the poor people to get justice from the court, the Supreme Court in the early 1980s devised a mechanism of public interest litigation, or PIL, to increase access to justice. So Supreme Court saw that the poor people are not getting benefit from the court. Therefore, they introduced a system called PIL, Public Interest Litigation. That was in 1980. So what is this public interest litigation? So it allowed any individual or organization to file a PIL in the High Court or Supreme Court on behalf of those whose rights are being violated. So according to this PIL, it is not necessary that the affected person should go to the court and file a case. Suppose I am a poor person, I don't know how to read and write, and therefore I cannot go to the court, I cannot get justice, I cannot pay fees to the lawyer and so on. So I think that there is no opportunity for me to get justice. But if somebody else see me suffering or my rights are denied, then they can go to the court and file a PIL. So not necessarily I myself have to do it. Someone else who sees my difficulties, who sees my problems, they can help me. So it may be an organization, it can be another lawyer, it can be a NGO. Anybody can go to the court and file that such and such person is denied justice, such and such person is not able to experience the fundamental rights and so on. So that way Supreme Court has done something good to help the poor people by allowing anyone to file a PIL, public interest litigation, in the either in the High Court or in the Supreme Court. So the legal process was greatly simplified, and even a letter or a telegram addressed to the Supreme Court or a High Court could be treated as a PIL. So again Supreme Court made it more simple that you no need to go to the court to file a PIL. You can simply write a letter, or you can even send a telegram message, or you can send an email message to the court, High Court or Supreme Court, and that will be considered. So by sitting in your house, you are able to fight for justice. You are able to fight justice for your brother or for your neighbor or your relative, whoever it is. Not necessary that you have to take leave from the office and go to the court and file PIL. Not necessary. By sitting in your house itself, you are able to fight for justice. And in the early years, PIL was used to secure justice on a large number of issues, such as rescuing bonded laborers from inhuman work conditions and securing the release of prisoners in Bihar who had been kept in jail even after their imprisonment term was complete. So earlier, after starting this PIL, many people used to fight for the rights of the people, especially for people who are bonded labor. That means people are kept like a slave and made them to work, and they are not given wages, they are not given freedom, they cannot stop work and go, they cannot escape. Therefore they are like a slave, they are bonded laborers. So somebody filed PIL in the court so that these people who are kept like servant or slave can be freed, they can go and live a free life. Or in Bihar there was incident that some prisoners, they were sentenced as a punishment given to them, but even after the sentence was over, they completed their fixed term in the jail. Still they are not set free. They are made to continue to live in the jail. So in such cases, somebody took interest to help those people, file PIL on their behalf, and the court took initiative to release them. So that is what we can do for others as well. So did you know that the midday meal that children now receive in government and government aided school is because of a PIL? See the photos in the right and read the text below, understand how it came about. So now most of the government schools and the government aided schools, they have got midday meal system. So in the beginning it was not there. So that midday meal system was begun or started because some people filed a PIL in the court. Because of that, the court told the government to start the midday meal system. So you can see the picture in your, there are 4 pictures are given there, and you can see the description is given about the photo at the bottom of the page. So first photo shows that in 2001, the drought in Rajasthan and Orissa meant that millions faced an acute shortage of food. So you can see the land is very dry, there was no rain, there was complete drought, and therefore people are going to face acute shortage of food. And the second one shows, meanwhile the government godowns were full of grain. Often this was being eaten away by rats. So the government godown, we see sacks of rice, how much of rice was there, and the government was not giving to the poor people. It was kept there and the rats were coming and eating away, but the people were dying of hunger. And the third photo we see, in this situation of hunger amidst plenty, an organization called the People's Union of Civil Liberties or PUCL filed a PIL in the Supreme Court. It is stated that the fundamental right to life guaranteed in Article 21 of the Constitution included the right to food. The state's excuse that it did not have adequate funds was shown to be wrong because the godowns were overflowing with grains. The Supreme Court ruled that the state had a duty to provide food to all. So this organization called People's Union of Civil Liberties, they filed PIL in the court saying the people are dying of hunger and the government godowns are full of grain and the government is not doing anything. And it is the right of the people, the fundamental right is a right to life. And so right to life also includes right to food. So it is a duty of the government to provide food for the people, to keep them alive, to keep them from famine and so on. So therefore the court also accepted that PIL and told the government it is your duty to provide food for the people. Then fourth photo shows, it therefore directed the government to provide more employment, to provide food at cheaper prices through the government ration shops, and to provide midday meals to children. It also appointed 2 food commissioners to report on the implementation of government schemes. So the court took action. Court told the government that you have to provide food for the people. You have to distribute the grain that is there in the storeroom at a cheaper rate through the ration shops. And you also have to give food to the students, children who are going to the school at midday. They have to prepare meal and give to the students, to the children. So the present day midday meal system started because that organization called People's Union for Civil Liberties, they filed this PIL. Therefore the court took initiative and explained that it is a duty of the government to provide food for the people, and therefore now we have the midday meal system in government schools as well as in the government aided schools. Now, for the common person, access to courts is access to justice. The court exercises a crucial role in interpreting the fundamental rights of citizens, and as you saw in the above case, the courts interpreted Article 21 of the Constitution on the right to life to include right to food as well. They therefore ordered the state to take certain steps to provide food for all, including the midday meal scheme. So, for the ordinary people, they cannot go and demand government, give me that, give me food. What? They can go to the court, and the court will tell the government to do it. And if the court says, the government will have to obey it. So, for the common people, for the ordinary people, it is easy to have access to the court, at least because of this presence of the PIL, and the government will take, the court will make sure that the government is carrying it out its directions. Then, however, there are also court judgments that people believe work against the best interests of the common person. For example, activists who work on issues concerning the right to shelter and housing for the poor believe that the recent judgments on evictions are a far cry from earlier judgments. While recent judgments tend to view the slum dweller as an encroacher in the city, earlier judgments like 1985 Olga Telvis versus Bombay Municipal Corporation had tried to protect the lives of the slum dwellers. So sometimes we see that the government is trying for development and they ignore in that process the poor people, and therefore when government is going against the poor people, interests of the poor people, the court can intervene. The court can protect the lives of the poor. Simple. So let us see a case that was taking place in Mumbai. How the court came to the rescue of the poor people. So that case is called Olga Tellis versus Mumbai Municipal Corporation. So in the case, two parties are there. One, Olga Tellis is filing a PIL against the Municipal Corporation of Mumbai. So let's see what was the occasion, what was the case. So the following excerpt from the judgment point to the ways in which the judges linked the issue of the right to life to that of livelihood. So there is a right to livelihood. Earlier we said the court is ruling right to life includes right to food as well. Now we come to another aspect of that right to live. It includes right to live of livelihood. Right to livelihood. So the sweep of the right to life conferred by the Article 21 in the Indian Constitution is wide and far-reaching. Life means something more than mere animal existence. It does not mean merely that life cannot be extinguished or taken away, as for example, the imposition and execution of death sentence except according to the procedure established by law. That is but one aspect of the right to life. An equally important facet of that right is the right to livelihood, because no person can live without the means of living, that is the means of livelihood. So the Article 21 in our Constitution says that everyone has got right to life. So it is not enough that you say you live, but you should have a standard way of living. You cannot live like animals. So human beings are dignified. Therefore, you should have proper place to live, proper place to work. You should have proper food to eat. All these are including the right to live. So the government makes sure, or the government has to make sure that the people of its country are living in a dignified way with proper dignity, not like animals, but a better life than that of animals with the food, shelter, clothes, and so on. But the eviction of a person from the pavement or slum will inevitably lead to the deprivation of his means to livelihood is a proposition which does not have to be established in each individual case. So, in the Bombay, the people were sitting on the roadside and selling things, vegetables and other small things. So, they have no other place to go. They have no shop of their own. Therefore, they spread one sign on the roadside. They sit there from morning till evening and they sell, and they get very little income from that, and they are managing their family. So, the Bombay Municipal Court or Municipal Council, they said all those who are selling things on the roadside or in the footpath, they should be evicted. They should be sent away. They should not be allowed to sell there. So the court, somebody filed PIL and the court gave its verdict. So the present case that Facts constituting empirical evidence justify the conclusion that the petitioners live in slums and on pavements because they have small jobs to nurse in the city, and for them there is nowhere else to live. They choose a pavement or a slum in the vicinity of their place of work, and to lose the pavement or the slum is to lose the job. The conclusion therefore is that the eviction of the petitioners will lead to deprivation of their livelihood and consequently to the deprivation of life. So the petitioner argued that these people are sitting on the roadside and selling because they have nowhere else to go, they have no other work to do. Therefore, if you stop them from doing this work, that means telling them that you have no right to live, because they will not have any other job, they will not have any money to buy the necessary things for their life, and therefore slowly they will die. So when we tell them don't sit here and sell, we are depriving them of their livelihood. We are depriving them of their life. So if government is telling them don't sell here, then government should provide them another place for them to sit. Just telling get out from here is not okay. That is against the right to life. So the petitioner argued in that way, and the court listened to their petitions. Then another issue that affects the common person's access to justice is the inordinately long number of years that courts take to hear a case. The phrase justice delayed is justice denied is often used to characterize this extended time period that courts take. So another thing that the problem people face from the court is we file a case in the court and it takes many years sometimes for the court to start attending that case. So that is the problem that India faces. The court is giving importance to other important cases, and a poor man's case is pending there. It will be postponed and it will be taken up maybe after many days or many months. And then the poor man is waiting for justice, and his justice is delayed. And that's the saying, justice delayed is justice denied. So therefore it is important for the part of the court to speed up listening to the cases and to provide justice to the people at the earliest. You should not make them to wait and delay, but give them at the earliest so that they can restore their fundamental rights. Then let's see one case. In a speech made on 26 November 2007, the Chief Justice of India K.G. Balakrishnan noted that. So in that year, the Chief Justice of India was K.G. Balakrishnan. Then the Indian Judiciary consists of one Supreme Court with 26 judges, 21 High Courts with a sanctioned strength of 275 judges, working strength of 597 as on March 2007, and 14,477 subordinate courts or judges, working strength of 11,747 as on 31 November 2006. So according to the data of 2007, how many judges we have? In the Supreme Court we have 26 judges. Supreme Court 26 judges. Then High Court we have how many judges? We have 21 High Courts. Therefore we are supposed to have 725 judges we are supposed to have, but we are having only 597. So supposed to have 725. So the government has not appointed judges, so many judges are less there. Then in the district court, we are having how many? We are having 11,767. But actually supposed to have 14,477. So this is, we are supposed to have this many judges, but We are supposed to have this many judges, but the government has failed in its responsibility of appointing the judges. Therefore, we are having only this many judges. So there are many vacancies are there, and the government has to take initiative to appoint more judges so that the cases can be heard and justice can be given faster and faster. People will be able to benefit from the courts. Otherwise, the poor person will be filing an FIR or PIL and waiting for his case to be heard and waiting for the judgment to be delivered. So that should not happen in a democracy where the judiciary is independent. It should be able to satisfy the poor person by giving them justice. So however, in spite of this, there is no denying that the judiciary has played a crucial role in the democratic India, serving as a check on the powers of the executive and the legislature, as well as in protecting the fundamental rights of citizens. The members of the Constituent Assembly had quite correctly envisioned the system of courts with an independent judiciary as a key feature of our democracy. So though we have all these drawbacks are there, mistakes are there from the case of from the side of the court and from the side of the government. First of all, the cases are delayed and the sufficient judges are not there, and sometimes the rich people get benefit or priority, the poor people are sidelined. So all these are there, but still as a whole we can say the court has played a very important role in delivering justice to the poor people. And it is because when our leaders made the constitution, they specifically mentioned that in the constitution that the judiciary will be independent. So if it was not independent, then the situation would have been worse. The people would not have got justice. People would not have got the judgments in their favor, or they would not have got the right judgment, which would have been always influenced by other external forces. So we have got a democratic country. We have now democracy. We have the judiciary as an independent institution, and they are qualified, the well expert in law people, the judges are there, and they are delivering justice to the poor people. So still drawbacks are there, mistakes are there, but still we need to trust in this system of law, so that our country, our courts can continue to help the poor people and continue to take the side of the afflicted and the offended, so they can be given justice. So that is all that we have from this lesson about the judiciary. We saw how the judiciaries are functioning, how the poor people have got access to this law, how are they helped, and so on. So I hope you understood nicely. So try to read this lesson again and then clarify your doubts. Okay? So I will send you the class notes later, and then you will be able to write it down. Then also at the end of that lesson, certain very important terms are given there. So try to read the terms and understand. These are the terms that we generally use in the courts, like acquit, to appeal, compensation, eviction, violation, and so on. So these words are very key words that we use in the court terms. So try to understand these words and try to get maximum benefit from it. So thank you for listening. Have a nice day. Bye.